dedicated Ask Me Anything session, and we will take your questions from the chat box at that point of time. So my name is Dr. Mugdha Lele, and I'm the host for this event today. The agenda is, first I'll give you a brief introduction about Venture Center and the TechX.in vertical at Venture Center, who is leading this program. Briefly, I will also talk about the initiative, the outreach initiative that we have taken up along with ANRF. So it is ANRF plus Venture Center Outreach Initiative. I'll introduce the speakers and then we'll begin the session. Briefly then, talking about Venture Center is almost 20 years old now, and we offer different things in our ecosystem, where the main key part is mentoring. We also have a lot of funding programs, starting right from fellowships to proof of concept grants, to prototyping grants, to seed funds, to CSR funds. There are a lot of infra facilities. There's a funding database which is available, and Venture Center has been able to put in place a lot of important partnerships which are crucial for innovators to take their journeys ahead. So Venture Center, it is based on the National Chemical Laboratories Innovation Park campus in Pune, and such kind of events, we do several of them at regular intervals. Up till now, we have worked with almost 1,000 plus startup teams, of which 300 plus have been in physical incubation with Venture Center. We also specialize in spin-off companies. I understand that a lot of you are faculty in academic institutions. So do reach out to us if you are interested to take your innovation ideas ahead via a startup, and Venture Center can handhold you in that particular aspect also. It's a big campus, it's a huge team. We have specialized resource centers in IP facilitation, tech transfer, regulatory facilitation, a lot of advanced prototyping facilities, analytical facilities, and mentors, experts-wise, we have a very good ecosystem in place. And as events, we have been saying, these are some of the events which we are doing regularly at every month in terms of these webinars under this ANRF Plus initiative. TechX.in vertical at Venture Center is a specialized technology transfer hub at Venture Center, which specializes in technology commercialization, helping academia, putting the policies in place, helping them to file IP. And when we say filing IP, it is open not only for academia, but also for innovators, and we help in decision support for the academia. We also specialize in industry academia partnership, which is a dedicated vertical under the TechX.in services. And for any of these services, please feel free to reach out to us. These are our coordinates for reaching out to us for these specialized services. Now let me briefly talk about the ANRF Plus Venture Center Outreach Initiative. The broad scope is on intellectual property, patents, technology transfer, licensing, and very, very broadly innovation management. How do we do this? We have regular activities which we have announced. One is an online help desk. So there are dedicated links for each of these initiatives, and we will be putting them up in the chat box as we move ahead in the session. There's an online help desk to get your queries in the broad innovation management domain answered. There are specific one-on-one mentoring clinics on IP-related questions. So anything under the intellectual property domain, may it be patents, may it be design registrations, may it be copyright, trademarks, anything on that, specific questions will be addressed one-on-one in these mentoring clinics, and there's a sign-up link which we will put in the chat box. In addition to that, there will be free access to webinars, some of which are available on our YouTube channel, and we will put those links also in the chat box. Plus these webinars, we have already done one on what is intellectual property in April 2026, and this is the second webinar in this series on what is the ANRF policy around IP. So this is a specialized session around this topic, and the third one which will come in on 11th of August, and that is specific on how to draft intellectual property, how to draft patents. So that will be the next upcoming webinar. These are free webinars. Feel free to use those webinars. Our website address is also given at the bottom of this slide. So broadly, when we are talking about this outreach initiative, it is strengthening IP awareness and translational research, guidance on IP strategy, ownership, licensing, commercialization, structured expert support and curated knowledge resources, enabling deep science to innovation outcomes, and we are aligning with the mission-driven research goals. So that is what is broadly happening under this ANRF Plus Venture Center Outreach Initiative. Now let us switch gears and move to today's session, and I am now going to introduce both the speakers of the talk today first, and then after the talk, I will introduce the experts who are going to answer the questions in the Ask Me Anything session after the talk. So the first speaker for today is my colleague, Dr. Vidula Walimbe. She is a PhD in law from Symbiosis International University, plus she has done her postgraduate diploma in IPR from Nalsar University. Vidula is also a registered technology transfer professional, which is an important credential in the technology transfer domain. Her expertise is in patent analytics, prior art searches, patentability assessments, patent landscapes, and FTO, experiencing over different domains like pharmaceuticals, biotechnology, medical devices. She supports IP strategy, competitor analysis, and technology commercialization for industry as well as for academia. So, briefly about Vidula, I have introduced her. Moving on to my another colleague who is the second speaker for today. She's Meghana Bhandari, and she's an MTech in biomedical engineering from IIT Ropar. She also has a postgraduate, done her postgraduate research on intranasal delivery system for drug delivery system for Alzheimer's disease. Meghana has experience in biomedical engineering, digital health, and innovation management. She has contributed to several programs at Venture Center, supported by various funding agencies like UNIDO and BIRAC. And she has expertise in mentoring early stage startups in the domain of broadly healthcare, biotechnology, and biomedical engineering. So with this brief background, I'm going to stop my screen share here and requesting Vidula and Meghana to take this session ahead.
So, yeah, thank you. So, thank you, Mugdha ma'am, for the kind introduction. Just give me a minute so that I can share screen. Are the screen slides visible in full screen mode? Thank you. So, Mugdha ma'am has briefly introduced what we are going to do for the session today. But just to spell it out there clearly, let me also tell you that we will have an interesting relay of speakers. So I'll just begin with giving a brief introduction about ANRF, about the MAHA programs, the MAHA AI for Science and Engineering and the MAHA MedTech mission. And then I will pass the baton to my colleague, Dr. Vidula. She will be talking about understanding the ANRF IP policy and guiding principles for grantees. She will again pass the baton back to me, and I'll be covering specific IP terms of the MAHA AISC mission and the MedTech mission. And then in the end, we will have a very interesting Ask Me Anything session, which will be joined by 2 members from the ANRF team. So I'm sure you wouldn't want to miss that, and let's get started. So ANRF, most of you might be aware that ANRF has a very long and rich history, right from the establishment of the Science and Engineering Research Board, the SERB, its establishment, how it flourished, and eventually how it transitioned into the ANRF that we know today. But just to give you a summary of the entirety of it, ANRF was established through the Act of Parliament, the ANRF Act 2023, to promote a culture of research across the universities, colleges, and R&D labs. ANRF basically acts as the apex body that provides high-level strategic direction to scientific research in India. Some of its key objectives I'll be highlighting here. Although ANRF has a concrete list of 12 objectives, I'll just be focusing on a few of them, which interestingly also happen to be the basis of the MAHA missions that we'll be focusing on in the later part of the slides. So one of the key missions of ANRF is supporting the translation of research undertaken in capital-intensive technologies. It also is important that we understand that ANRF is going to encourage collaboration between scientists within and outside of India to enrich the Indian scientific ecosystem, seeding, growing, and facilitating research at academic and research institutions in universities and colleges will also be one of the key objectives there, with research and development projects, fellowships, creation of centers of excellence. About the MAHA programs. Now, most of you might have come across these announcements that ANRF has launched the MAHA EV mission, the MAHA water mission, the MAHA MedTech mission. Ever wondered what is the MAHA in these missions? So let me just briefly talk about that. Let me just break it down for you. MAHA, the MAHA in the MAHA missions, is an acronym which stands for Mission for Advancement in High Impact Areas. These are basically mission mode projects that support priority-driven, solution-oriented research by funding large-scale, multi-institutional, multidisciplinary, and multi-investigator projects, consortium projects that address India's most pressing challenges in the socio-economic and technological landscape. For example, the MAHA EV mission. The MAHA EV mission basically addresses the Indian challenges in becoming independent in the EV space, the global competitiveness in the EV space. Similarly, the MAHA MedTech mission becomes the talking point for addressing challenges about Make in India, the indigenous development of high quality imported medical technologies, again to become independent in that space, so on and so forth. Now let me just pass the baton to my colleague Dr. Vidula to help you understand the ANRF IP policy. Thank you.
Thanks, Meghana. Thanks, Mukta, for the introduction. So, as we move on now in the session, which will talk about understanding the ANRF policy and the guiding principles for the grantees, I have divided this session into two parts. The first part is we will understand certain basic concepts. So, why we have included the slides is there are many terms, many terminologies, which will come when we are discussing this policy. So before we start, we first understand what are these concepts, what is the actual definition. Then we will move on to the ANRF policy, and then the third part we will be covering the guiding principle for the grantees. Okay. So what are the basic concepts that I would like to introduce first? We will first start with the introduction to intellectual property rights. So what do we mean by intellectual property and what do we mean by intellectual property rights? So as WIPO has defined, intellectual property refers to the creation of mind. These could be inventions, this could be in the form of certain literary works, this could be designs, these could be symbols or names and images which are used in commerce. Now, when we say intellectual property, there also are certain rights which come with this property. So, how do we define intellectual property rights? So, what are rights? Rights are something that is given to a person for the creation. So, this creation, as I said, this could be in the form of certain inventions, literary works, and the creator, this right is given to the creator to prevent others from the use of his creation for a certain period of time. So this period of time is defined and it differs for every different intellectual property. Now to broadly tell you what are the different intellectual property rights. First is, we all are aware, there are patents. Patents are certain industrial, these are the novelty, inventive and industrial application inventions. So they are the creation of the mind. Copyrights relates to creativity and literary work. Trademarks, they might be in the form of logos, words, certain symbols or slogans. Patent, plant variety protections, these are new varieties with distinctive and uniformity and stability. So patent variety protection can be obtained if you have a new variety. Design, this is an industrial design that constitutes for ornamental aspect of an article. Trade secrets, these are one form of intellectual property and they are protected through confidential agreements. So most of these definitions, I've given the source below, they're taken from WIPO and WTO. Now to move on to the further concept of creator and ownership. So now we understood what is intellectual property, what are intellectual property rights. So each right creates certain certain rights for the creator and for the ownership. So what do I mean by creators? So let's take this with an example of patents. So in a patent, a creator is the inventor. Inventor is the one who has developed the invention, okay, or who's a part of that invention. Ownership rights, so inventorship rights is different from an ownership rights. Inventors always may not be the owners, and owners can choose to give commercialization rights to others. So this is basically will help us to understand further when we talk about what ownership rights mean in an ANRF policy. So now the question arises, how do we decide these rights? So we know intellectual property, we know the rights that are coming out of it. So we have defined also what are these rights, who gets the right, who's a creator, who's an inventor, who gets the ownership. So now we will see how the rights are decided. So the right to be recognized as a creator, for example, in case of patents, it is the inventor, as I said. This is decided by the law. So there are certain forms that tell you, who is the true inventor, they call that. The right of ownership of an IP. So this comes with different, under different scenarios. The host institute has certain policies. So whatever, as per the policy, the ownership is defined. If there are certain employment agreement, that also defines the IP ownership. Certain funding or grant agreements also decide the IP ownership, and collaborative agreements can define the IP ownership. Now, who can use this IP ownership? The right to use, trade, and commercialize the IP. So again, there are certain rules and regulations there. The host institute or the employee's policy decides who the right to use or commercialize the IP. The funding and the grant agreement decides the right to use or commercialize the IP. As I said, also collaboration agreements and certain license, assignment and option agreements decide on the rights to utilize this IP. So with this, we have finished the basic concepts of understanding what is intellectual property, what are intellectual property rights, how do we define a creator, how do we define an inventor, what are the rights, how the rights are decided, how the ownership is decided. Now we will move on actually to the ANRF policies. So this is a screenshot of their website. The ANRF has 4 policies which are defined on their website, out of which we will be discussing only 2 today. First one, that is the intellectual property policy and guiding principles for the grantees. This session I will be taking. And the point number 3 of open license for software, models and data sets, this will be again taken by Meghana. Okay, now we move on to the actual IP policy and the guiding principle for grantees that have been stated in the ANRF policy. This is a screenshot of the policy document. There are a total number of 4 pages. First a page tells is the actual policy documents. It has 8 points, 8 clauses, which we will discuss in detail. And the later pages, these are the guiding principles. This is called as the Annexure A, which has 16 points in it, and each of this we will be discussing in detail. Below is the link to this policy document. Okay. Now we will move on to the actual policy documents. So the ANRF policy is aligned with the National Intellectual Property Policy that was declared by the government in 2016. And the overall objective and principles of the ANRF policy is to ensure support for research, innovation and entrepreneurship. So you'll find that in the bracket I have mentioned the clauses which are there. So the first page that we showed that the policy document and the clause which it corresponds to. The policy document also states that the IP which is arising out of the research that has been funded by the foundation is an asset and it must be appropriately harnessed in order to maximize the socio-economic impact and achieving public good. So the core aim here is to support research innovation and to check that the whatever is the research or the IP that is arising out of this funded research has good socio-economic impact and achieve public good. Now, we have understood the concept of ownership. So, in the policy, the ownership is defined in the following way. The IP that has been resulting from the research that has been funded by the foundation, it vests with the granting institute, so which receives the grant. In case if there is an individual or an internship or a fellowship program who receives this grant from ANRF, in such a case, the policy of the host institute will be applicable. That is point number, or that is clause number 5. Also, the foundation specifies certain deviations in the policy document, which are the deviations for the general IP vesting clauses that we saw in point number 4 and 5. What are these certain deviations? That in certain cases, the foundation may feel that the grant in these deviations are in exceptional situations, as they mention it, which where these exceptional situations might be in the in critical research areas, sensitive research areas, or strategically important sectors such as nuclear, atomic energy, defense, aerospace, and public health. The ownership clause here for clause number 4, 5, and 8 focus on who owns the IP that has been generated out of the research which has been funded by the foundation. If it is for an individual who receives the grant, the policies of the host institute applies, and certain deviations which the foundation may cite from the general principles will be for certain exceptional cases or sensitive areas which are important sectors related to nuclear and atomic energy or public health. So this is the gist of the ownership clauses that have been stated in the policy document. Now we move on to the commercialization part. So the commercialization in detail is also covered in the guiding principles. So we will be discussing that in details when we go to that section. But the policy states that the guiding principles, which are, as I said, which are specified in Annexure A, that is the guiding principle, this will be the basis for the commercialization of the IP that has been generated from the funding of ANRF. So what the grantee should follow, what are the certain principles that they need to take a look into are defined there. Here also the foundation mentions that there might be certain specific binding principles for licensing of the IP. This includes open licensing, where the foundation determines that there is a need for wider public dissemination, rapid technology acceleration of the research in India. So this again defines certain specific principles for licensing of IP. So we saw that certain specific principles are defined for ownership, certain specific principles are defined for licensing of IP too. Now what are these in details? We will be covering it later. So that ends the main policy document. So it was an 8-pointer document talking upon ownership, what is the core objective of the ANRF IP policy, how it is aligned, and what are the commercialization basics. Now the guiding principles, as I said, there are a total 16 points that we'll be covering here. The first is, it talks about the dissemination of knowledge. So whatever is the research that has been conducted by the grantee after receiving the funds from ANRF, they need to be there has to be certain dissemination of the knowledge. So how is this being done? This can be done in 2 ways. One is through peer-reviewed publications. One other could be through certain IP-related filings. So what does the guiding principle 2 say? Grantees should make efforts to disseminate knowledge arising out of their research to the society for achieving public good. This can be in the form of peer-reviewed publications. It could be through the development of certain products, processes, or technology for deployment on scale, or this could be through IP protection and tech transfer. Now, there's one point that we would like to highlight here is regarding the Saral AI. This is an ANRF supported tool which converts research papers into multiple formats. So the research papers can be converted into certain reels, they can be converted into podcasts, certain slides or posters, and it supports 21 Indian languages. So the dissemination to the society, the objective that has been stated in the guiding principles of ANRF policy, the Saral AI supports, the Saral AI tool supports this guiding principle here. So this was just a quick mention that we thought would be important for the today's audience to know what is dissemination and how it can be done. So the guiding principle, as I said, it is important that whatever is the knowledge doesn't stay with the grantee. It gets goes to the public domain in any form. It could be in the form of publications, IP, or through product or services development at a larger scale. Now the second, third clause, or the third guiding principle which has been stated relates to the approach for IP protection. So what the grantees need to do? The grantees may decide on the appropriate approach for IP protection. So how the IP will be protected, what will be protected. So how have they stated this? They have stated this on the basis of a decision on an assessment of finding the research that is being undertaken. What is this assessment? This assessment is in the form of novelty, inventiveness, and applicability of the IP protection. So you understand the main three factors for filing a patent, or relevance in the aspect of deciphering of the new concepts, understanding, and theoretical framework. So the path of deciding the appropriate approach for IP protection may be decided by the grantees, is what the guiding principle number 3 states. Now there is a requirement of intimation and acknowledgement to the ANRF. So the research that has been granted by ANRF there are certain intimations that need to be provided to them. This is guiding principle number 4 and 5, which states that if there are certain publications which have arisen of the research, if there are any filing of IP, this could be in the form of patents. As we said, it could be in the form of certain designs, copyrights. If there are any grant of IP, if there is any commercialization of the IP, this needs to be intimated or needs to be acknowledged. The foundation support needs to be acknowledged in these cases. So any filing intimation needs to be given. And how is the acknowledgement done? If there is any milestone publication, it can be done through tagging or any other means which the grantee is obtaining to. And if there are publications which are done, ANRF needs to be acknowledged for the support that has been provided to the grantee. In case there are any collaboration or partnership agreements, so these are joint agreements which might happen between two grantees, the same also needs to be informed to ANRF for the support that they have provided to them. Now coming to the next part in the guiding principles is the commercialization part. So as we had said that in the policy, the point number clause number 7 mentioned that there are certain principles that for commercialization that need to be followed as per Annexure A. So we will be going through these principles for commercialization. The first part talks about IP administration and decision. So the implicit point here is that the grantee is responsible for filing the IP, prosecution of the IP, and maintenance of the IP. So we have previously seen that the grantee has to decide upon what will be the IP that will be filed depending upon certain basis of novelty, inventiveness. Similarly, they are also responsible for filing the IP, prosecution of the IP, and also the maintenance. The grantees also may need to have a committee. This committee will constitute of certain experts from the field of scientific, industry, finance, and legal experts. Why is this committee required? The committee is required to review the IP filing, understand the grant status, to review certain tech transfer and licensing deals that might be happening, certain agreements that might take place, evaluation of the IP, and advise on the modalities of commercialization and whether it should be an exclusive or non-exclusive licensing. So the IP administration part basically covers the need of what the grantee should come up when they for IP filing, and also setting up an committee for review. So the general principle for commercialization that has been stated is where IP protection is obtained, it is the responsibility of the grantee to ensure that the products and the technologies are commercialized for social impact. So this was also the core objective that we have seen, that the IP that has arisen out of funding of the research that has been received through ANRF, it should be commercialized for the larger social impact. Now, how can this be done? The decision to decide, or to decision in the way the mode of licensing of this IP has to be done is again with the grantee. So the grantee may decide the means and modes of licensing. It can be done on case-to-case basis, but the thing is, it should be in a transparent manner, and certain considerations are required. So when we say it, and for an assessment, for filing an IP, what are the assessment requirements? Similarly, for commercialization of the IP, there are certain considerations that the grantee needs to undertake. This consideration certain pointers are being given there as the nature of the technology, what is the technology readiness level, what are the market risks, what is the investment requirement, how much development is required for the technology to be commercialized. So the grantee needs to understand these pointers when considering IP licensing, and this will be on case-to-case basis. Now, the preferred licensee which have been mentioned in the guiding principles is the preference should be given to small and medium enterprises and startup entities that undertake manufacturing in India. So when a grantee thinks about licensing the IP, the preference should be given to accelerate manufacturing in India, and this could be through the SMEs and the startup community. The policy document or the guiding principles also specify that there are certain when there is a licensing arrangement that is being considered during the commercialization of the IP. The important point here is there should be government. The rights should be preserved for Government of India. The Government of India rights are irrevocable, royalty-free right to practice, and require the license to grant sub-licensing to the responsible applicant. So when licensing agreement is drafted, there are certain pointers that need to be considered to preserve the rights of Government of India here. Now, why it is important? This is necessary to fulfill certain public interests, including health and safety and security needs of the country. Now we move on to the licensing terms. So what do the guiding principles say for the licensing terms, or what the grantee should consider? A standard licensing agreement framework may be developed by the grantee. Now, when a standard licensing agreement framework has been developed, this should be informed to the foundation. What is the standard licensing agreement? Usually, the preference should be given to non-exclusive licensing, where the grantee considers exclusive licensing. So non-exclusive is something that is preferred, but in some cases, if there is an exclusive licensing that the grantee feels appropriate, the following principles are applicable. First is such agreements must be limited in terms of the time period, in terms of the geography of the jurisdiction, and the usage. The public interest concerns should be concerned by ensuring availability of these products and technologies which result from the research in the Indian market and affordable price. And the clause 7 in the policy document that we had seen earlier, that the foundation may specify certain binding principles for licensing of the IP, which include open licensing. So this open licensing part, Meghana will be covering after my talk here. And the foundation also feels that there is a need for a wider public dissemination and rapid technology acceleration of research in India. So, in short, this slide basically talks about what are the principles which guide on the licensing term. First is a standard licensing agreement. Preference should be given to non-exclusive license. If there are conditions where an exclusive licensing is required, what they might, what are they subjected to in terms of a limited time period, geography, and usage. Now, one point that has been mentioned in the guiding principles relates to the assignment or the transfer of ownership. Where there are requests which are received by the grantee for IP assignment and the grantee considers undertaking such an assignment, they require the founder's prior written approval, especially if such assignments may encourage for spin-outs and formation of startups. So, assignment agreement is something where the ownership is transferred. So, when such a clause, such agreement comes into a place, the foundation's prior written approval becomes an important point here. Also, if it is going to result in the formation of certain spin-outs and startups. Yes. So the good practices that have been stated, through the policy document and also through the guiding principles of ANRF, we can understand that what the grantee should do. Grantee has to decide on the appropriate approach for IP protection after assessment of the research. They should check the licensing capability and competency to scale up the innovation before it has been licensed. Define commercialization timelines in the licensing agreement. Consider public interest and affordable availability of the products for the Indian market. And set up a committee comprising of the scientific, industry, finance and legal experts who will review the IP filing, who will understand the grant status, transfer and licensing agreements, and ensure that the IP does not remain without being transferred or licensed. So these are the good practices, or the brief about what has been stated in the guiding principle in Annexure A. Yes, so from here I will transfer again the baton to Meghana. She will be talking about the IP policy for MAHA, AISE and open license policy. And then after that, we'll be open to take up certain questions and we will have a session of asking anything. Thank you, everyone.
So, thank you, Vidula. Let's delve a bit deeper into the IP aspects of the MedTech mission and the AISE mission. For the MedTech mission, it's pretty straightforward. MedTech mission follows the ANRF IP policy as has already been explained by Vidula. But just to summarize, the creator credits, the ownership rights remain the same. Just the commercialization or the utilization rights will be different. I've also pasted two very important points from the ANRF website FAQ here, just to highlight again that the IP ownership generated under the MedTech mission will be owned by the grantee itself, and the grant funding under the MMM mission also includes funding for regulatory processes and patent filings. The MAHA AISE mission, it is a bit different in the sense that it follows open license policy. The next few slides will be structured such that I'll first highlight what are the outputs expected from this program. And then we'll talk again about the creator credits, ownership rights, utilization rights. So for the AISE program, the key outputs expected are open source model, tools, autonomous laboratories, open source data sets, modular architectures, frameworks built on the FAIR principles, or a combination of all the items that I just mentioned. In case of creator credits and ownership rights, the creator credits and attribution for it should be displayed via a copyright notice, which I will be showcasing in the next slides. And the ownership again, which is very important here, is owned by the grantees themselves. In case of utilization rights, all outputs must be released under the ANRF open license, which in turn is adapted from the MIT open license, ensuring that there is open access, ethical use, fair usage, and global interoperability. This is just a one-slide brief information about the ANRF open license. The thing mentioned in the blue box is the exact copyright notice that I was mentioning about. Permission is hereby granted for free of charge to any person obtaining copy of the work or associated documentation files. Now, this work will include software codes, data sets, trained, untrained models, workflows, and modular architecture related tooling stuff that is developed from the AI models. Under certain conditions, first, inclusion of a copyright notice, just the exact notice that I tried to read out, provided as is where is basis without any warranty, responsible and ethical use, global interoperability, and limitation of liability. And I'd just like to quickly conclude by sharing a few links of the resources which you can go through to understand more about the open license policy, which also needs to be aligned with the national AI strategy and UNESCO's AI ethics recommendation. Thank you. Over to Dr. Mugdha again.
Thank you, Vidula and Meghana, for this session. Let us now move to the next important section of this session, which is Ask Me Anything part. So for this, I'm very happy to invite three prominent experts in this domain, Dr. Premnath, Dr. Monika Agarwal, and Dr. Thangaradjou. So briefly introducing the three experts, Dr. Premnath is Director of Venture Center and heads the INSEL Innovations. With his background in chemical engineering, he is also alumnus of the MIT and also Chevening Technology Enterprise Scholar in Cambridge, UK. He has played a key role in setting up the Intellectual Property Facilitation Center and the TechX.in, that is the Tech Transfer Hub at Venture Center. Moving on to Dr. Thangaradjou. Welcome, Dr. Thanga, for this talk. Dr. Thanga has a PhD in Marine Biology and Atmospheric Sciences at the Indian Institute of Sensing and Dehradun. He's trained there. His experience earlier is former Assistant Professor of Marine Biology at Annamalai University. And currently, Dr. Thanga is a Senior Scientist and Research Administrator with extensive experience in managing and supporting science and research initiatives in India. Dr. Thanga is the Program Leader for the MAHA MedTech mission at ANRF. Dr. Monika Agarwal, welcome ma'am to the session. Dr. Monika is a PhD in Chemistry from Agarwal University with a PG Diploma in Patent Law from Nazar University and certificate in US Patent Law and Practice from Fickey George Washington University. With a formal research experience at Shriram Institute of Industrial Research, she joined CSIR's Intellectual Property Management Division in 2009. She is also a registered Indian patent agent and has expertise in catalysis and analytical chemistry. At ANRF, she is Member Secretary for the Power Grant, Power Fellowship, JC Bose Fellowship, and Ramanujan Fellowship programs. Dr. Monika leads the MAHA mission's AI and AC mission at ANRF. So with this brief introduction, I'm going to stop share about this the speaker introductions and handing over the section to Dr. Premnath.
Hi, well, good morning still, and we have some time, I think. How much time do we have? About half an hour at least?
Yeah, yes.
So we have tried to address some of the questions online as it came. So now we have a chance to speak through some of these questions as well. So I first just wanted to take up a few questions from the online form that people had filled up, and I'll request Dr. Monika Agarwal to go first. Yeah. So one of the questions which came up is very generic and very foundational, which is why is this IP policy important and how is it going to help the researcher? Since you were involved in putting this together along with other colleagues at ANRF, I would like you to take that question.
Yeah, I will explain briefly. As our previous speaker has already mentioned that IP policy, why IP policy is required. Because when you protect IP or because many this grantee institution, they want IP policy of funding agency, because they want to know that whether funding agency will be partner or maybe ownership of for this IP. So we have cleared that we will not be partner of we will not own the IP created by the inventors, and it will be owned by the grantee institutions. And it attracts industry startups to take IP, because if you will protect the IP, then it will be easy to commercialize the IP. So now this is the era of innovation. It's not era of publication. So we have to create this IP policy. So IP policy is very important, and this is in line with IP national IP policy to 2016. Yeah.
Yeah. Thank you. I just wanted to ask a question to Dr. Thangaradjou about some of the mechanisms available for supporting some of these processes, especially in MedTech mission. I think ICMR's MedTech Mitra is also helping. So can you talk about a little bit of how researchers and grantees can fund some of these filings? And how they should go about it, and what would be your suggestions on different strategies they can approach?
See, ICMR is one of our partners, along with Gates Foundation, and some other agencies also now express their interest in joining the group. So, ICMR in principle, they are already implementing the Patent Mitra program for helping the people who want to do patents in the medical areas, biomedical areas. And any projects supported through this MedTech mission, they will be directly coming under the umbrella of this program. So they have the liberty to directly communicate with ICMR, with the MedTech umbrella, and they can get the direct benefits of filing patents and other processes. And ICMR is also extended their concerns. They're ready to give support to the PIs, whether it is funded by ANRF or other partners. They are ready to give their support in their biomedical clinical networks to test their products. So these are the two advantages through MedTech we are extending to all the PIs.
Are they able to cover some of the costs in the project costs in terms of the filing and prosecution costs? Can they book some of those costs?
Yes, if they are already proposed in the proposal, it has been recommended by the committee. Yes, definitely. Even if it is not being proposed, Gates Foundation is willing to support in such cases on case-to-case basis.
Okay. I think that's quite helpful. I just wanted to also discuss, Dr. Thangaradjou, you can also talk about cases. How do people handle situations where there are multiple partners and collaborators? What would be good practices there?
So the good practice is the lead PI and institution are the first responsible people in filing the IP. However, they have to take along all the partners involved in the grant. So, and they, before filing a IP, they should have an bilateral or multilateral agreement among the institutions and the PIs involved in the project. And then they have to get a consensus on issues, and then they have to go for the filing of IP. So it's basically the primary responsibility held with the institution of primary PI, that is principal investigator of the project.
Yeah, let me also add there that some of these collaboration agreements between different parties typically have clauses which take care of ownership, joint ownership if relevant, who will take the lead in administering it, taking decisions, acting on filings and prosecution, and also cost sharing and reward sharing. And typically these are built into such agreements, and these are important to have if you're entering into any kind of collaborations as well. I wanted to also ask a little bit from the AI side as well. In the AI mission, the primary outcomes are more of models, software, and so on, and data sets, right? What was the thinking behind positioning it as an open license kind of a framework for these kind of projects? Dr. Monika, would you like to take that?
Yes, we have adopted this open license policy because we are expecting some foundation models, data sets, and our architects will be developed under this AI for science and engineering mission. So we want that large community should be benefited from these models foundations. So we have a commitment from MIT. So our grantees should submit their foundation models, data sets, and architects and software tools on India AI portal. And we have created account for that. So they will submit these models under this open license policy, and it can be taken from there. So other industries or maybe a commercialized partner, they can take these foundation models and they can write proprietary code from there.
Yeah, there are some questions also which have come up about background IP. Would you like to address that, Dr. Monika?
Yeah, background IP will be with the owner of the IP. So that IP will be generated from the NRF funded institution, grants that can be taken care from the NRF projects. So that background IP will be remain with the owner.
Yeah.
As such.
So the project IP is owned by the grantee. Background IP is owned by whoever owns it
Owner
entering
of
into the project, right? And if there are multiple grantees, they can have an agreement about ownership of the project IP, I suppose, right? Between
yeah,
this.
as per agreement, as per MOU signed between the grantee institutions.
There are questions about some amount of, by the way, it's important to understand that a policy is meant to provide overall guidance. It does not necessarily detail out every possible situation, and some of those have to be taken up on a case-to-case basis in consultation with program managers at a suitable point. But that said, the overall theme is quite clear, and the overall guidance is quite clear. One more thing which Vidula pointed out was that there is a segment which is the policy, and there is a segment which is the guiding principles. The policy primarily puts down some very important points regarding ownership, and it basically, ANRF has provided ownership rights to the grantee, and that's a great opportunity for grantees to take it ahead and for commercialization and advancing it closer to market. And that also reflects some of the experience around the world where grantees having rights, for example, in the US, based on the Bayh-Dole Act, where the grantees were provided the rights, really accelerated commercialization. So in the same spirit, ANRF is doing this so that the grantees have all the rights to pursue it further as well. That said, there are certain guidelines under which it will operate, which Vidula has laid out for especially the generic IP policy. In the MedTech mission, Dr. Thangaradjou, would you like to talk a little bit about how people can bring in industry partnership, right? And what would be good practices over there?
So we actually expected, there should be a consortia should happen between academia and industries, especially our focus is light on the startups and MSMEs to submit the proposal in collaboration with academia so that there will be a process that R&D components will happen at academic place and its prototype development and commercialization will go to the industry partners, and in between testing of the prototypes and other things will go to the ICMR. So we expected the line of transition happening in the process, but unfortunately this was not happen in many of the cases. Many of the industries like startups and MSMEs, they applied directly, and academia has applied directly. So there is of course, we also got some proposals where there is a clear cut of transition happening R&D component to prototype validation, prototype development and validation, and commercialization process. This is, though in the first call for proposal, this was not achieved in a larger level. In the subsequent calls, we are expecting that there should be a collaboration across the entities, and then we are expecting a joint venture among the academia and industry for the full support.
Thank you. So, generally speaking, why it's quite clear that when the project is fully funded by ANRF, the ownership is with the grantee, and that grantee, in most cases, perhaps will be a consortium of academic research organizations. The startups can participate to claim some utilization rights, right? Of IP, and they could also be participating in the commercialization process, and that is something which is an important intention also of the program as well, right?
The fundamental principle is that we need to develop the Make in India concept in the end of the process. So any products which is developed through this thing, and the first priority should go to the Make in India process, and the products has to be developed in India at cheaper price, and it should be available competitively to all the sectors of the people.
Yeah, I'll just take one question from one of the participants online who has raised a hand. This is from IRCC, IIT Bombay. I've just requested you to unmute. Please just see if you are able to unmute. Can you unmute? Yeah.
Hello.
Please introduce yourself and then ask your question, please. Yeah.
Yes, sir. Thank you. Are we audible?
Yes. Go ahead.
Yeah. Hi. Thank you. Thank you for arranging this session. This is Manisha, technical officer from IIT Bombay. I'm attending this session with my team, and we have two observations over here and one query to ask to you. There are certain programs of ANRF which needs collaboration of industry partners. Suppose there are 90% of funding coming from ANRF and 10% coming from industry partner. The proportionate might change, and in that particular instance we need to have an agreements with the industry partner. What we have realized that some industry partners would want to have exclusive licensing provisions, and also they would want to have extended ROFR period, a right of refusal for exclusive license. So should we allow these provisions into our agreements? What is your take on this?
Yeah, so I will request the program managers to address some part of it, because these case studies will be evolving as we go along, okay, when as cases emerge. But broadly speaking, let me just add a few words out here first. The first thing is, if the program is primarily supporting IIT Bombay, for example, you are the grantee, the ownership rests with you. So there should be no conversation, hopefully, about that aspect of it. It is about the right to commercialize it, right? Now, in the right to commercialize, the provisions which Vidula mentioned recommend, by the way, first of all, it allows the grantee to set up a licensing agreement, a suitable licensing agreement, given the broad policy guidelines which are provided, right? And you need to justify it and aligned with the policy guidelines. If generally speaking, a non-exclusive licensing has been recommended for certain reasons, but there are provisions by which, if you think it is important to provide exclusive licensing, it will still serve the purpose of broader reach and adequate investment from the industry, or incentivize them to take up enough risks, then that case can be made according to the policy. Okay. The provision for assignments right now has been linked closely to startups and spin-offs, but it is something which can be requested if required from ANRF. It will be ANRF's decision at that point. Now, something like ROFR and so on and so forth will probably be built into the kind of licensing terms that you arrive at. So those, I think, will have to be thought through in the context of the policy. One cannot give a direct answer on that, but I'll request Dr. Monika and Dr. Thangaradjou to comment, please.
Monica, would you like to go first, or I can go?
Yeah, as I agree with Dr. Premnath, that is a case-to-case basis, and because it depends on how maturity level is the this technology, or what is the agreement between the this our grantee institution and the industry, because we are investing 90% and industry is investing 10%. So we have to see what is the best utilization of the IP generated from the ANRF supported project. So yeah, so I request Dr. Thangaradjou, maybe he can add some more points.
Yeah, the fundamental point of this commercialization process, exclusive rights, it's been very clearly indicated in our policy document, point number 15. If they are willing to take up something like exclusive licensing kind of thing, it should be for a limited period and limited geographical region, rather than it should be open for aware and for the world. And especially it should ensure those commercialization should ensure it should be available in Indian market on a affordable price. Okay, that is the most important criteria of supporting the R&D component in India. So people should think of the point number 15 before going for that exclusive licensing. And as Dr. Monika has pointed out, it should be, on case basis, institution may bring into the knowledge of ANRF, and if we find, it's very much essential for commercializing the product, we can take up those cases.
Yes. Yeah.
The
Thank
general thing, I mean, it's important to note that it's not that exclusive rights is prevented, but you have to justify it in the context of the policies. So the broad principle is broader reach, right? Affordability and access in India, right? Now, if you can justify a given set of terms, considering that the NRF is doing bulk of the funding, then it should be possible to discuss that with your program manager in the NRF. Okay.
Definitely. So at present, we are annexing the IP guidelines to any of our agreements, stating that IP guidelines of ANRF shall prevail in any conflict between the terms. That is what we are proposing at the present. One more feedback which we have received from our industry partners, the guidelines, the document guidelines has not been, do not have document reference number, or has not been signed by anyone, or it's not explicitly mentioned it will apply to guidelines like ANRF pair program. So how we can justify them? Would there be a document reference on IP guidelines, or would that be I mean, an industry partner is suggesting how we should assure that this is applicable to us, because it's coming as a standalone document on the net. So
But ANRF IP policy document on ANRF website should mean that it is something which is a default document applicable unless the particular scheme or the sanction order mentions otherwise, right? Wouldn't you agree, Dr. Monika Agarwal? I mean, I don't think you need more than that, but if your suggestion is that there should be a date and some kind of a
document identifier,
office
suppose
memorandum.
this order number or something like that is someone was referring.
In form of OM kind of thing.
Yeah. So that's a suggestion from them, which is fair. I think you can consider that if possible to include that.
There are two ways to interpret this one. All project sanction orders which ANRF issues, a point says that the IP emerges from the project should be dealt with as per the ANRF IP policy. This point refers with that, and IP policy is available in our official website. Beyond which, if some of the partners would like to have a number, it's very easy for us, and it's already been approved by a board, and I can easily put up the board reference number in that document.
Great.
Yeah.
That would be great, sir, because we totally abide by ANRF policy guidelines, but some of the industry partners says they have never received any email stating these IP policies will applicable.
It
So
is
that is
available in the
Yeah.
project sanction order.
okay, sir. Okay. Yeah.
Okay, thank you.
Thank you.
We'll move on. I'll request Dr. Monika to kindly talk a little bit about the AISC program and how industry can participate in it, and what would be some of the reasons why they would like to participate. We can't.
Yeah, actually, we this AI for Science and Engineering program,
Yeah, we can hear
yeah,
you now. Go ahead.
this AI for Science and Engineering mission we have launched in October, and under we have 4 verticals. So we have collaborated with the ministries, other partner ministries like MOES, DBT, and this DRDO and Gates Foundation, and now MIT has also committed 200 CR GPU for this program. So we would like to participate industry because we are giving GPU services through India AI portal. So maybe they can access these GPU services with the grantee institutions. So industry should participate in this program, and maybe some foundation models we are expecting that this is objectives of the program, that they will develop some foundation models to solve scientific problems. And this program is to bring AI experts as well as domain experts so that they can solve some of the burning problems. And as I said that MIT has committed to give 200 CR GPU services through India AI portal. So that will be a benefit to the industry. They can access GPU services, which is very difficult to get. And we will give 100% subsidy to the grantee institution. And this is my request to the industry to come forward and participate in our AI for Science and Engineering program, and solve the burning problem of the country. Yeah.
I wanted to just add also that the open license that is talked about. It's in the document you will notice that this is based on the MIT license, and it's an open access license, which is a highly permissive license. So it can be used. What is put out will be open access. But on top of it, industry partners can build proprietary platforms for commercial purposes, and that is allowed by the MIT license. So that is possible for startups, MSMEs, industry. The purpose of the AISC mission is the reason open license is provided is to accelerate innovation in a domain where things are moving very fast, and therefore keep it as open access, open data as possible. But on top of it, people can build many things as well. There are a couple more questions. I will give them a chance, but please keep it focused on innovation management. We cannot take up questions very much on things which are not related to this particular MAHA missions or generally innovation management. Okay, yeah, please go ahead. I think we should have allowed
Murli
Pandey, please.
Hello.
Yeah, go ahead, please ask a question.
Good afternoon, sir.
Yeah,
Sir, I have a Serve project, and in that project, I am running the 3rd year, and we have filed. We are in the 3rd year of the project, final year. We have filed a complete specification this year in the month of June 2026, and a provisional specification was filed for this patent only in June 2025. And I'm from BITS Pilani, and in our institute there is a IP cell, and they have a format in which we had a place to mention the funding agency where we have put the Serve and along with the project ID also. So do I need to do any other extra things, sir?
Yeah, I think the only ask from ANRF is that whenever you are publishing something or patenting something, please intimate ANRF so that they can have it in the records and it reflects in the impact that ANRF is creating through their various programs, right? So in your reports, it should be mentioned and it should be intimated. That's all that ANRF has asked. If anybody would like to add anything, Dr. Monika or Dr. Thangaradjou, please do.
No, I agree with you, because we need to keep records, and that whatever knowledge dissemination or whatever technology commercialized or patent filing should be intimated to NRF funding agency.
Thank you, sir and madam, for the input. When we submit the UC, at that time, the portal asks us to submit the details of publications, patents, if all those things. So we are putting there, we are providing the details in progress report also. So is it sufficient, or I need to send email or some other things also?
I think that should be sufficient.
That is sufficient.
And we are also making sure that wherever we are publishing in the acknowledgement section, we are putting serves your name along with the project ID also. For
Thank you.
One point I would like to add here is,
be it review article or research article, whatever.
Sorry, just 1 minute. Let Dr. Thangaradjou answer.
Yes.
so whenever we are submitting the annual progress report or the project completion report, you are updating about the publications and patents. But in most cases, the patents will come to a final process, or the publications may happen after the completion of the project. So it doesn't mean that you have to only report with the annual report or the project completion report, beyond which also something fruitful comes out of this project. Our online portals allows you to update those details in the completed project section. So I request all the participants here, to keep updating the progresses happening with reference to patents or the publications. You can update in the portal at any point of time, even after completion of the project.
Yeah, thank you. We'll just go to Navrinder Kaur.
Good afternoon, sir. I'm Dr. Navrinder from Amity University, Noida. So, our team is building an application which will integrate multiple data sets for analysis using clinical samples. So, sir, my question is that should we develop this application first and then go for copywriting it, or we can copyright first and then build it up? What would you suggest?
See, let me just comment first on this, and then I'll request Dr. Monika to go. See, copyright is something that whenever you put down on your copyrighted material, a symbol of a copyright and say that it is copyrighted, that is also respected. Okay, there is also a formal registration process which you can do, but it's not. You don't have to wait for that. You can just put it in any kind of code that you put together or a data set that you put together, and it the credit is yours, right? And it's copyrighted to you or your organization as the rules might, as your institutional policy will allow. So there's no need to wait, right? You can do it right away in whatever that you're creating at every stage that you're creating. Okay?
Yes, sir.
Yeah.
Yes.
So anyway, Dr. Monika, do you want to comment on this?
No, sir. I agree that copyright is basically for artery work or literacy work or any software or tools. Maybe that, as you mentioned, that anytime you can, register for copyright after writing, or maybe during the writing of software or data sets.
Okay, I think we have a few more hands up, but what we'll try and do is close in a few minutes. So I just want to...
Before we move ahead, I would like to alert everyone, the feedback link is projected on your screen as well as it is there in the chat box. Please do give your feedback. It is valuable to make the next sessions more useful. Thank you.
Yeah. There are a few other questions which have come up in the registration forms for this event, which have to do with, since you have the benefit of Dr. Monika here, and she is an experienced person in the, these are more patent law related, so I will just request you to quickly address those if it's possible. There were questions on what are common. One important question was, which is a little from people who have been practicing research on a more fundamental side and have not looked at IP. We're asking the question: what are the benefits for researchers in IP? Okay, and what are the common mistakes that people make in IP?
Actually, when they people do research, they generally don't recognize that this research outcome has potential for commercialization. So they publish first. They don't go for IP. So first, you please go to, whenever outcome comes, you please go to your IP cell or your tech transfer cells and ask for whether this research outcome has potential for commercialization. After this checking patentability criteria, novelty, inventive step, and industrial applicability, these are three criteria for patent application. So if once they will check and they will go, they will give you ahead, then you please file. If this outcome has this potential for commercialization, go for IP protection. If it does not have any commercialization potential, please go for publication. So first secure your IP, first secure for your priority date, only published, and please first check with the potential of commercialization of your research outcome. That is the my request to the researchers for this to carry out research. Yeah.
Yeah. One of the common problems that I see is that people wait for their publication to get ready and then do the filing. And it's important to understand that for a patent filing, you often just need to describe what you did and what is the effect that you got. You don't need to get into all the mechanistic details and so on and so forth, which basically is required in publications, which means that you can actually file your patent much in advance of publications. You don't need to wait for your manuscript to be ready. And and it's actually a fairly fast process if your organization can manage it in a speedy fashion, right? So it's not so complex. I wanted to add just one more point is, for many of you who are wondering why you should file patents, it's important to understand that all researchers value their ideas and like to see many people use it and put it to use. And if there's a product, that it should reach many people who can benefit from it. And the best thing you can do to make that happen is to create a protection which attracts attention of those who will invest in your ideas, their time, money, and efforts. And that is primarily what IP does. Okay, so that is the best reason that you should be filing your IP and so on, so forth. Not, of course, if it results, you're also able to control its further development. You are getting formal credits as a creator, but if your institution has a revenue sharing policy, you will also get rewarded along with it. But that said, the primary reason should be to attract interest of investors and industry participants and so on and so forth, to take the idea ahead and not let it languish along the way, just because you've not taken efforts to protect it, right? Okay, so one final question I'll take from...
One more point here, Dr. Premnath, because you need not to file your patent application, full application at the time of filing. You can file provisional application, and patent office give you 12 months to file complete application. So whenever, you need not to wait for publication. So immediately, whenever you get IP, immediately you file provisional application, and by the time it gives you to 12 months. So within 12 months, you can complete your patent application and you can file complete application with your claims.
Yes. So I think I'll take a few more questions online here. Archana Chaudhary, please, can you please keep your questions brief and we'll try to cover as much as we can in the next 8 minutes and then close. Yeah.
Yeah, sir, this is Dr. Archana, working at IIT Indore and as executive manager, taking care of IP and tech transfer. So my question is specifically related with the pair scheme of ANRF. So does our ANRF has a specific guideline for the IP protection of these projects, or as a hub institution, we should be making the guidelines for the IP generated through these projects?
See, we are not keeping any specific IPs for individual programs. See, the IP policy of the ANRF applies to all the grants which is supported by ANRF. And being the hub institution, would like to have some understanding between your spoke institution. You can keep an MOU with all your network people with the larger scope of IP policy of ANRF in mind. Otherwise, we are not going for individual program-wise IP policies.
Yeah, I think that answers your question, right? Let's go on to the next one, please. This is Dr. Shashi, my CKN.
Yes.
Keep your questions short.
Yes, yes. A very short question. I'm working here at SVKM CNMMS Shirpur campus in the School of Pharmacy and Technology Management. Also looking after the IP cell through ISE as well as SPUC for the university. Here, a small question that we have the National Innovation and Startup Policy 2019 for students and faculty, and the ANRF IP policy is there. A small question is whether this IP policy is aligning with the National Innovation Startup Policy for faculty and students.
Yeah, my understanding it does, right? Basically, you must have noticed that the ownership is resting with the grantee institutions, right? Okay. So the grantee institutions policies apply when you're doing some of these activities. There are only some provisions for how you utilize and commercialize, which ANRF is recommending under guiding principles, right? With the goal of reaching as many people as possible. Please also realize that different funding programs can prioritize different things. Okay, in certain programs it might be indigenization and affordability. In certain other programs it might be global excellence and global reach and so on. So you should look at the specific program and see how it aligns with different types of startups that you might be creating or your students might be creating. Not everything will be, looking at one set of goals. Okay, so the rights, it's basically the rights you provide to your startups, to your student startups, and so on and so forth. Those rights you need to temper it based on what the funding agency's guidelines are. Okay, and you might have also noticed that ANRF has also allowed instances of assignment to startups or spin-outs, which is very good, right? Provided, of course, that you make a case to them.
Okay, got it. Thank you.
I'll just go ahead. Last question online from Dr. Mansoor Mir. I'm sorry, I may not be able to take too many since you want to close by 12:30, right? Mansoor Mir. Please ask your question. Yeah.
Hello.
Yeah, go ahead. We can hear you.
Yes, sir. Thank you for conducting such a wonderful seminar, sir. So I want to ask if I want to apply for two of the patents for two of the drug molecules which we have been testing in our lab. So is an ANRF providing any support for that application or?
Yeah. Dr. Thangaradjou, do you want to take that? These are molecules, I think, drug related. If it's part of a given program, if you're a grantee, you can build some cost into it for patent filings. If it is not, then you need to explore other ways to fund it. Anything in health, you can look at some of the ICMR funding mechanisms available through MedTech Mitra, right? And so that's what I would suggest. Anything you want to add, Dr. Thangaradjou?
So you are largely covering that one, until the project is alive, they can use the contingency grant and other grants for maybe used for filing the patent. But beyond the project period, they have to explore the other opportunities by various sources. Yes.
I had also put down some of the mentoring. If you have anything relating to IP, tech transfer, venture sector does run a mentoring service which is free, so you can use that. I put a link in the chat box. You can please sign up and use that as well. Also, there is, I think, clinic. Would you be able to? There's a clinic which we run from time to time. This one, which we have, I've also put a link to. Please use that as well. Okay. There are a few last questions which I thought I can. These are a little more complex, but maybe we'll give it a shot, Dr. Monika and Dr. Thangaradjou, before we close. These relate to essentially different types of partnerships where, say, there are different academic institutions. Here is a case which Dr. Uttam Pal has mentioned about 2 academic institutions are grantees of the patent. Filing joint patents with academia and industry together significantly slows down the process to patent applications as per the feedback by industry. How shall we proceed in this case? When there are multiple collaborators, are there some good practices for speeding up the process of filing? I can also comment after you do, Dr. Monika. You're on mute, right? Dr. Monika? You're on mute. Can you unmute? There's a problem there. Just check.
I lost my network. Can you please come again?
Yeah. No, Mike. The question was regarding when there are complex collaborations, the process of filing becomes slow, and the industry complains. So that's what the question is. Is there, how should we proceed in cases where there are multiple grantee institutions and industry involved and so on and so forth?
Actually, it depends on MOU. As we mentioned that what clause, IP clause is there in MOU. And so based on MOU clause, if a process is slow and industry is complaining, maybe in communication, maybe you can communicate with the industry, and based on this communication gap should not be happen, and you should communicate to the industry that because of this reason this process is slow, and so maybe, yeah, this is very complex process, but this communication, I think, is the key of resolving conflicts.
So I can just add here that online, if you go, you will find several templates of collaboration agreements which have been put out by many institutions around the world, including something called a joint invention administration agreement. There's also something called Lambert agreements, which are available from the UK, which are available online. So if you look at those templates, the way people speed up the administration process, so a couple of suggestions are: one, that you assign administration of patents to only one party in the collaboration, and it's not a joint activity there. It's only the decision-making process also can be streamlined, where one person takes a lead, one organization takes a lead, and not everybody, right? You can also decide how you want to handle costs accordingly. So even the licensing discussions can be with one party taking the lead. And by the way, this is not something which is alien in India. We are familiar with cases where CSIR institutions and other institutions have done this with industry partners, where only one party is representing the whole technology, rather than all parties being at the table at all the times. Right? That's the fastest way to do it. But of course, some of the parties have to agree to let one party lead the conversation. So that's how it usually works. right? There's also a question about what if ANRF and non-ANRF funding supporting one patent, whom to take approval and what is the procedure? I just want to point out that you don't need to take approvals for filing, what ANRF has said is that ownership rests with grantee. Okay, so that is also something which helps you. But you want to add to that, any of you, Dr. Thangaradjou or Dr. Monika, please?
No, sir, I think on the whole it covers. Dr. Monika would like to add something.
Yeah.
No, as we mentioned, and it's mentioned in our IP policy that there is no need to take permission of IP filing. But if you are commercializing or if you are giving license, maybe exclusive license, you have to take or assignment. Then you have to take permission from ANRF. And if you are filing patents or if you are doing this non-exclusive license, you have to intimate to ANRF. That is so. Yeah, it's mentioned in our IP policy very clearly.
Okay, sorry, we are running out of time, so we will have to close here. But we have noted down your questions and we will get back to you on all of those. I'll just request save the questions so we can respond to those. Let me thank Dr. Thangaradjou and Dr. Monika for joining us today for this session and responding to all the questions that have come in. And many of you who have participated, not only through your questions which you sent in when you were registering, but also today in person. The video will be available online as well as so you'll be able to refer back to this later. So on that note, I'll pass it on to Mukta to close this session, please.
Let me thank all the experts, Dr. Premnath, Dr. Monika, and Dr. Thanga, for joining this session, and also the speakers for today, Dr. Vidula and Meghana, who gave a good session. I take this opportunity to also alert everyone about the upcoming talk in this series, which is around IP drafting, coming up on 11th of August, how to draft your claims and file a good IP. This will be on 11th of August at 4 o'clock, and again it's a free talk. We will circulate the details once again to all those who are interested and those who have registered for today's talk. You can sign up for that session, and we request you to please give your feedback for today's session. The link is there in the chat as well as you can see it on the screen. So with this, we close today's session. Thank you one and all.
Thank you very much. Thanks.
Thank you.
You saved the